All right, I speak to hundreds of business owners who get sued in ADA cases and need a defense. And one of the things that I hear all the time, over and over again, is, but my building was built 100 years ago. My building was built 50 years ago. This was way before the ADA. Am I not grandfathered in? There is no such thing as being grandfathered in under the ADA. So any business or property owners out there who think that, well, your property was built so long ago that the ADA, which was passed in 1990, can't possibly apply, that's wrong. However, there are different standards that apply to different buildings based on the year that they were constructed. If they were built before the passage of the ADA, then they only have to make changes to the extent readily achievable, which means accomplishable without undue burden or expense. That gets a little bit complicated in and of itself, but they don't absolutely have to make the changes unless they renovated after the ADA was passed and did not renovate in a way to comply with the ADA, in which case they have to make the changes to the maximum extent feasible, which means if it can be done, it does have to be done. If it can be done without tearing the building down, which means it would be structurally impracticable, then it must be done even if the building predates the ADA. It gets a little bit confusing, but there is no grandfathered in. So if you're a business or property owner, if you represent business or property owners, and you're thinking, well, my business is so old, the ADA construction standards really don't matter, they don't apply to me, that's wrong. You need to look into it to make sure that you're meeting whatever the applicable standard is.